People v. Tevin Tully. Excellent start to the new year. Matter is submitted. Stevens v. Skolnick. And so you would like to submit and rely on your brief?
Unless the court has any questions for me, I'm happy to.
No, but thank you for coming. That matter is a submission. C. King, submitted. Landis v. 383 Realty Corporation.
Mark Berman for the respondent. Don't see counsel, the appellant here.
No, she was telling her to sit down. You can remain standing, Mr. Berman. What would you like to do, Mr. Berman?
I had requested 15. I don't think without the appellant here, I need 15. So why don't we make it 6?
Okay, good. We'll make it 3. 3061-63 3rd Avenue versus Solomon. And then we have Bajakarti Realty versus Solomon. So I'll do them separately. So the first one, 30-6163.
Appellant requests 7 and 3. Respondent requests 8.
Okay, so that's great. So 6 and 2 and 6. Now the second matter, Bajakarti Realty versus Solomon.
Petition appellant requests 6 and 2.
Respondent requests 5.
625. Easton Effects versus 3911 Lemon.
8 and 5.
You're the appellant, yes?
Respondent 3911 and other entities other than trust 6. Trust 5.
5, 2, 5, and 5. People versus Douglas McFarland. That matter is submitted. Allied World versus Greater New York.
Appellant requests 5 and 2. 6 minutes for respondent.
525. Reyes versus Perez.
Good afternoon, Your Honor. Appellant
Good afternoon to you.
5 and 1, please.
There's no one to do a one with. I mean, there's no respondent, so.
None of the respondents.
No, they didn't come. So what would you like to do?
I guess I would like to have 2 minutes in case you have a...
Nah, that's where we were going, but okay. 2 minutes. Gilead versus Manhattan Nouveau. Oh, but thank you for coming. Matter is submitted. Meyer versus Cabot Lodge.
Defendant responding, Your Honor.
Yeah, just wait until the calendar is called before you make your mad exodus. I'm sorry, yes, sir?
Defendant responding.
So we need the appellant. Do we have an appellant? Okay. Yes, sir? 523. DeGraff versus the City of New York. Matter is submitted. People versus Jonathan Jolivet. You guys come and then you submit. Wow.
6 and 2, please, Your Honor.
I'm sorry, Ms. Meese, what did you say?
6 and 2, please, Your Honor.
People? Oh, good. 524. Dell versus Intercontinental Hotels. That matter is submitted. First case for argument would be Landis versus 383 Realty Corporation. Now you can leave, those who submitted. Thanks for coming again. See you soon. Or not. New year. We're happy to be here. Mr. Berman.
Good afternoon, Your Honor. Mark Berman from Bond, Shennick & King. I guess people did not want to prepare over the holiday weekend, although the court did. I represent the respondents. We're here today to seek affirmance of the surrogate's decision after a 5-day trial that took place a year and a half ago, where the surrogate reviewed the evidence, made credibility determinations, and, Your Honor, findings of fact. Appellant made a big deal in their moving papers about this court's standard of review. The First Department is pretty crystal clear in a bench trial where the court has made credibility determinations. It is not a de novo review, as he claims the court in DiLorenzo versus Winterman states. But that state court, quoting the Court of Appeals, says you give deference when there are findings of fact which are considerations related to the credibility of witnesses.
So the only issue in terms, well, that I saw or believe that may be relevant is the fact that the two witnesses were denied, the plaintiff was denied the right to cross-examine the two witnesses, Wallach and Moreno. And then Mr. Wallach, apparently there were issues as to him in terms of, I think, disregarding a prior court ruling or something like that. And Mr. Moreno, there were issues in terms of assignment of a homeless assistant or things of that nature. So what about that in terms of the court's failure to allow the cross-examination of those witnesses?
It was harmless error, but there was no error in fact, because what the cross-examination was on was irrelevant credibility issues that are completely extraneous to the action. We have a super, we have a bookkeeper. The super allowed some homeless people in. It goes, okay. That goes to issues of credibility.
What about, who's it, Wallach, who was the individual who disobeyed a prior court order?
In an unrelated matter, unrelated to this case, in another action, my learned adversary found out that he had not complied with a certain court order. He erred. Okay, that goes to issues of credibility. The court heard the oral argument on the issue, Your Honor, and decided that it was collateral and irrelevant, and counsel was able to, I would say, based on my recollection, cross-examine Mr. Wallach for, at least two hours that afternoon.
Thank you. Thank you very much. Next matter for argument is.
Thank you very much.
Take care. 3061-63 Third Avenue.
Good afternoon, Your Honors. Eden Burkett for City Appellants. Your Honors, this is one of more than 4 dozen Article 78s on essentially the same issue that Petitioner's Counsel has commenced, seeking to use the clerical error provisions of 11206 of the Administrative Code as a way to essentially circumvent the exclusivity of Article 7 for misclassification claims. Petitioner's Counsel notably was also on a matter that this court decided just last week in matter of Downing Street, in which there was a different misclassification claim that was also sought to be brought through clerical error, and this court found that the challenge to the criteria or method of classification was not a proper subject matter for clerical error, and that Article 7 was the exclusive remedy, and the same result should occur in this case as well.
Counsel, in the city's view, looking at the discrepancy between the city register designation of the property as non-residential vacant land and the real property transfer report designation of the property as non-residential vacant land, those contrast with the zoning map, as you know, which says vacant land / zone commercial or Manhattan residential. So in the city's view, in Article 78 is in a, let me change that. The Department of Finance would have jurisdiction because that would be a clerical error as opposed to a classification. Can you explain the city's take on this?
Well, the purported clerical error that the petitioner has submitted was that it pertained more to the provisions of RPTL 1802, which is the classification provision, and the assertion was that placing the property in Class 4 was a clerical error instead of placing it in Class 1. However, petitioner, as I mentioned before, has submitted nearly, more than 4 dozen claims on the same subject matter. So petitioner's counsel knows full well that the interpretation adopted by the Department of Finance as to the proper classification of vacant land with a commercial overlay is that it's considered not zoned residential within the meaning of RPTL 1802, and it was properly classified as Class 4 property. So this was, that's exactly and precisely the misclassification ground under RPTL 706, which states that the misclassification ground is a challenge to the determination by the assessor as to which class the property should fall under RPTL 1802. So this is a matter of judgment. This is a matter of substance. As the Court of Appeals held all the way back in 1877, so this is 150 years of jurisprudence that stands behind the distinction between clerical errors and those which are errors of substance, judgment, or merits. And that's exactly what petitioner's counsel was challenging in the guise of a clerical error. This was clearly not a typographic error, some sort of computer glitch. This was a reasoned consideration. And in fact, while the city's contention is that the substance of what class the property should fall is not a proper subject for clerical error,
So in the city's view, the correct procedure is to bring a tax certiorari proceeding, is that right?
Correct.
Under Article 7?
Under Article 7, that would be the exclusive remedy for this claim. And despite all of these proceedings that petitioner's counsel has commenced, and the city's response being essentially the same, that clerical error is not for errors of, for challenges to the determination, it's only for bona fide clerical errors. There has been no challenge in any of the Article 7 proceedings that have in the various cases. In this matter, I don't believe there are any Article 7 proceedings, but in other matters there have been. But in any case, that would be the exclusive forum for adjudicating misclassification.
So were any time limits exceeded with respect to bringing an Article 7 proceeding?
Well, it would.
If you know.
For this matter, the time has passed, and that's one of the reasons why Article 7 is different than an Article 78 brought to challenge a clerical error, is that the timing of an Article 7 is a year-by-year timing, and there has to be an administrative exhaustion, usually by March 1st, sometimes March 15th, depending on the property class of the year in question, and then assuming exhaustion in Article 7 before October 25th. So the failure to preserve the right to Article 7 is a bar to seeking relief for those particular tax years. If the court has no other questions, I'll sit down.
Thank you.
Good afternoon. May it please the court. My name is Jason Boker. I represent the petitioner respondents.
So doesn't this case hinge on how the property should be characterized under the real property tax law? You know, depending on what your interpretation of that provision is, would affect the outcome of this case. Do you agree?
Correct. The core of the case is the parcels in question. According to RPTL 1802, how should they be classified? That is the core of the case.
That being true, how the property should be characterized under the real property tax law be classified as misclassification of property as opposed to a determination of how to interpret the statutory provision?
So there's a long history of what constitutes a clerical error or error in description, obviously going back at least to 1877, as counsel mentioned, but the law has changed drastically over time. the most recent iteration of the changing of the law happened in a case called Better World. In Better World, in 2014, there was a tax class 2 property that being billed as a tax class 2 that was really should have been a tax class 1. The court in Better World, the Appellate Division 2nd Department, stated that that does fall within the Administrative Code 11206, clerical error, error in description. It's not just a missing comma somewhere. The court found there that that does include those types of errors, a misclassification of a property. After that case was decided, the Department of Finance in a revamped the entire clerical error
You're
in
saying
description
even
rule.
if it's not a ministerial error, like, oh, look, you said it was this rather than that, but actually a legal interpretation of a statute to which reasonable people could differ, your position is that still would come under misclassification of property.
100%. In 2016, the Department of Finance promulgated the clerical error rule, error in description, which is RCNY 5302. And if I could read you the preamble to that, which is very elucidating as to what they were trying to do here.
But counsel, how is this an error? I mean, you have 3 documents, 2 of which are in synchrony, and the other one which is different. So how is that an error as opposed to a substantive finding that has to be addressed?
Because that is exactly what the clerical error and error in description rule provides. It provides specifically a misclassification, a building class that is not correctly billed in the correct building class is fully correctable under 11206 and RCNY 5302. The preamble was very clear. The law itself, I mean, the 5302 B10, which is the error in description, is exactly what this case is about. It says inaccurate building class that affected assessed value. And it gives an example where a warehouse is billed as a K1, but it really should be a different class. It's exactly what's happening here. We have a vacant parcel, what is even the proof in the pudding of it, which is not even discussed at all by respondents in any of their papers, is that the Department of Finance, when they are posed with a clerical error submission for a vacant land that is solely residential without this commercial overlay, they will use the clerical error rule and adjust that to make it from a tax class 4 to a tax class 1.
But isn't that somewhere where you could just look at the records and say, oh, yeah, this was misclassified? We can look at these records and determine, based on the face of these records, that an error was made and how it should be classified. Whereas here,
Precisely.
it's a legal interpretation. Reasonable people could come to different interpretations how to interpret the tax law.
I respectfully disagree, because here's the same situation. The question here, it posed to the Department of Finance, is the mere fact of this a commercial overlay on a residential property. Does that magically transform a residentially zoned property into a commercially zoned?
That sounds very much like a substantive question, doesn't it?
No, I mean...
You're saying that this is something that a clerk could change?
The rule of 1802, RPTL 1802 is clear. It says residentially zoned. It's clear what is a residentially zoned property. Department of Finance has made this error in description by saying if you have a commercial overlay, now that's a commercially zoned property. There are over 4 dozen cases that were brought. 35 cases as of this morning. We got the decision this morning. 35 Supreme Court 35 decisions, about a dozen or 15 justices, all agreed that this issue is a clerical error, and that just because there is this commercial overlay does not somehow override RPTL
So, counsel,
1802.
In your view, your client has the option of either doing an Article 7 tax certiorari proceeding or filing an Article 78?
I will say one better. It's not just my client's review. That's what the law says. Article 7
So
clearly...
the answer is
Yeah, the answer is yes. The Article 7 says unless otherwise provided by law, and the RPT and 11206 and RCNY 5302 says this is not the exclusive remedy. You can bring in Article 7. There is a choice to what you can do here. Yes.
Counsel, I thought you conceded that there was no clerical error, that would result from a minor mistake or inadvertence, right? Did you not?
I'm not following the question.
Did you not in your papers? I thought that your argument was that a clerical error, that no clerical error could result from a minor mistake or inadvertence, right?
No, I think what we were saying in the papers is that the law, the 11206 and RCNY 5302 clerical rule is not just what happened in 1877 potentially, where it was just a missing comma. There are about a dozen to 15 different types of delineated errors, clerical errors and errors in description that are listed in the statute, or in the rules, I should say, that are correctable and are routinely corrected by Department of Finance.
Right, so you're talking about a comma, but is this something that could be corrected by an aide or an administrator, what have you? Is it not something that goes to the actual misclassification?
No, that's exactly correct. Instead, there should be a box ticked here that says this is a tax class 1, not a tax class 4. That's all that has to be done here. There was a tax class error that was made. It's an error in description as provided for in 11206 and the clerical error rule. This is exactly what that rule for. And if you want me to just briefly read that preamble.
We have
I mean, you have it in the record. But
have
the
it in the
preamble to 5302 clearly says that now after Better World, we are expanding what we normally would. We always had the power. The department says that we always had the power to make these types of corrections. And now to have a better tax roll, we will entertain all of these clerical errors and we delineate each ones. Now, what is not, and they also delineate which ones are not included. What cannot be included in the clerical error? An assessed value issue. You cannot come with a clerical error and say they used the wrong assessment procedure to come to the assessed value. That would not be included. But a building tax class, an incorrect square footage, things that are not necessarily a missing comma, those are correctable and are routinely corrected by Department of Finance. We put in our papers example after example, and the most prevalent example to look at here are vacant land parcels that are tax class 4, but they don't have the commercial overlay, and Department of Finance will use their clerical error rule to change those to a tax class 1.
Thank you, counsel.
Thank you, Anders.
Okay, so I think that
So, do you interpret RCN 5302 the same way?
No, Your Honor. The rule was in fact it was promulgated after the decision in Better World. There hadn't been a need for a rule, and the department hadn't been using the full extent of the clerical error power, and the statement of rulemaking indicated that it was going to significantly expand its scope. However, that does not mean that it escaped the narrow bounds that the legislature set. I won't belabor the point, but in our briefs, which have been submitted to every justice that has heard one of these matters, is that we painstakingly trace the legislative history of 11206, which originates in the 1897 Greater New York Charter. And there have been various court decisions, including in the Second Department, which the court in Better World ignored, that have found that clerical error is not a substitute or a replacement or a fallback for those who do not wish to or have not preserved their right to Article 7.
How do you see the statement by your adversary, the answer yes, to the question as to whether his client had an option to either go the Article 7 route or the Article 78 route? Is there really that kind of option available?
Well, in terms of the option, I'm not sure I understand the question.
Can a person or a company decide that they're going to go the Article 77 route or the Article 78 route in order to challenge a misclassification?
No, the case law is very clear that Article 7 for misclassification is the exclusive remedy. In fact, the 6 days after the court holding in Better World, the Second Department in a case called Tricarico held that in a challenge, it was a plenary action, it wasn't Article 78, but that Article 7 was the exclusive remedy for misclassification claims. And if I could just sort of continue my point, that the idea that the clerical error rule that the Department of Finance enacted somehow wiped the slate clean of all of these precedents is frankly absurd. The rule was promulgated in accordance with the narrow purview that the legislature had passed, and in accordance with the many court holdings that have held that this is a narrow power, it's discretionary, and it is not a substitute for the exclusive remedy.
So the next case, thank you both. The next case is by Qatari Realty versus Sullivan.
Good afternoon, Your Honors. This case is obviously a different case than my Scott Goldberg for the appellant is a different case than 3061, but there are a lot of issues that are related. First of all, the lower court in this particular case,
Counsel, who do you represent?
I'm sorry, I represent the appellant, Bajaktari. So in this particular
Isn't this case even harder for you, though, because we have a case right on point where we address this very issue of undervaluation, overvaluation, involving the discretion of assessor, and that's the classic paradigm of an Article 7 case that you have to bring it.
Justice Kern, give me 2 minutes to just, please, I know that we're going back to 1877 and 1925, and that's what the respondents rely upon in this case and the other case, as opposed to relying upon a 2016 enacted clerical error rule. They don't even discuss in their papers in this case the clerical error rule. They don't even mention the section that's applicable. Instead, they talk about a Herman's case, which was right
What
after the
about
Reconstruction
matter of
period.
9 Orchid, which seems very, very on force with this case and controlling on this case.
But if I can,
Why is that case not applicable here?
which case?
Matter of 9 Orchid.
Okay, 9 Orchard. In that case,
Orchard.
the petitioner in that case actually submitted an affidavit from an appraiser showing that, no, you're not valuing the property correctly. It's a valuation issue. We're not asking, in this case or the other case, to value the property because of income approach or market value
Right, but
approach.
isn't whether or not to grant a J51 tax abatement inherently based on evaluation of the property analysis? Which an assessor has to do its own individual determination to decide.
First, the whole issue of Article 7 in this case and the other case was not invoked by the administrative agency. It would require this court to deviate from fundamental Court of Appeals precedent to even find for the respondent in this case, respondent in the other case, respondent in this case, the appellant in the other case, against us. Listen to the...
They found it wasn't a misclassification, therefore that would be the only remedy that would be available.
But there's Court of Appeals in Trump Equitable says a fundamental principle of administrative law long accepted by this court limits judicial review of an administrative determination. It says the court is powerless to sanction determination by substituting what it deems a more appropriate and proper basis.
But counsel, the court, if the administrative determination was that there was no misclassification, no clerical error or no misclassification, which is the only way you can bring the Article 78 a fortiori, then you have to go to this Article 7. It's not, they don't even have to expressly say that because that is the only other remedy. You are correct. The only issue that we do ultimately have to determine in this case is not whether Article 7 is the only remedy, but whether there is any misclassification. And they clearly did address that by saying there wasn't.
But Justice Kearns, after 2014, what the Department of Finance did, it enacted this clerical error rule. Give me 2 seconds. Real Property Tax Law Section 701 says, a proceeding to review an assessment of real property shall be brought as provided in this article unless otherwise provided by law. Next step, 11-206 says, power of the Commissioner of Finance to correct errors. It says here, the Commissioner of Finance may correct any assessment or tax which is erroneous due to a clerical error or error in description. Now comes 2014, the Better World decision, and Justice Balkins dissented in that case, and they make much of that, Corp Counsel, but the dissent was, you didn't define what a clerical error is, an error in description, so we don't know if one really exists. The Department of Finance heard that, and in 2016, they enacted a clerical error rule. Let me please read, statement
Counsel,
of basis.
I don't get where you're going. So the issue here is window replacement, right? There was window replacement, and in your view, that should have increased the property assessment, right?
That's a subset, but we didn't even get, the lower court didn't get there. The lower court didn't get there. It dismissed the case saying it should have been brought as an Article 7, not an Article 78. I want to explain to this court.
So did the plaintiff ever present the J51 certificate of eligibility to the Department of Finance?
Of course, yes, and it did receive the abatement benefits. It did not receive its exemption, even though the certificate of eligibility specifically provided that it's eligible for 14 years of exemption benefits. And the assessed value, the year after the work was done, went from 900,000 and change to almost $1.5 million. It went up 50%. So we're not asking that you change the value. We're saying a portion of that should have been allocated towards a physical increase, and 53-02B2 specifically says that if there's an equalization increase, that should have been a physical, it's correctable.
And that finding by the assessor was premised on the fact that the rent roll remained the same and there was no change due, for example, to an MCI increase. Am I right?
Even if the rent roll remained the same, obviously the Department of Finance increased the value by $500,000, by 50% in 1 year. In 1 year. This is a rent-stabilized building. My client can't just raise his rents. He's stuck to a certain formula. His assessed value increased by 50%. HPD said he should have an exemption for 14 years, and because the assessor didn't issue that partial exemption, 53-02A1 says a partial exemption is an error that's corrected under clerical error rule. He didn't receive it. But I need to get back, please, because
Are you saying the assessor made an error, though?
Yes.
So isn't that inherently in Article 7 when the assessor makes an error, as opposed to an error in description?
The error, but the-
Misclassification, the error was, you're saying the error was the assessment, that the assessor was incorrect.
Okay, if the court's not willing to accept this and proceed under the clerical error rule, then you're just gutting the rule and you're just allowing the Department of Finance to apply this rule whenever it wants, make these corrections whenever it wants, and treat people in a disparate manner. And whenever it doesn't want to do so, they won't be subject to scrutiny.
But Counsel, what I'm not understanding is we're talking about the valuation, the tax valuation of the property. And your contention, it appears to be that the assessor made an error in the assessment of the tax for the property, on the property.
Not as to the gross number. They increased it, the valuation, by $500,000, 50%, from $1 million roughly to $1.5 million.
Right.
And even without a physical increase being issued, we've cited to 4 examples where properties did receive J51 exemption benefits. We cited to an assessment manual that says when windows are replaced, a physical increase should be issued. None of that happened. And what's happening here is the court, with all due respect, seems to be lost on the idea that in 2016, the Department of Finance enacted this clerical error rule, and they said that historically, this is the basis and purpose, historically, the authority granted under Section 11026 has been exercised narrowly, leaving unaddressed many categories of errors that could be corrected under this section. This rule significantly expands the categories of errors for which the Department of Finance will offer an opportunity to correct. And it says it'll go forward as well as 6 years back. The court's missing this. I'm sorry, with all due respect, you're missing this. And they use this day in and day out. They correct vacant land issues. It's a zoned, residentially zoned vacant land. It doesn't have a commercial overlay. They'll correct it. It's residentially zoned. It has a commercial overlay. All that means is you can build a 30-unit building and put some stores on the bottom. It's still a residentially zoned property, and now they're not willing to correct it, although they did correct the first 5 cases for 13 block and lots, and they don't even talk about that.
So are you also, so was there
You're
a
arguing the
claim?
other case now.
I am arguing both cases because it's the same issue. This court is hung up on 1877 and 1925 as opposed to the idea that the Department of Finance said, we are willing to do this. There's a public policy to have a tax roll that's accurate and correct, and we want the ability to correct this, and they do correct it.
So did you also argue that they were applying this rule unequally?
Of course, it's disparate treatment. It's in our papers. They don't like the way Scott Goldberg looks. We're not going to adjust it. I can show you a case that was adjusted last week where it was
put
done
that
as a
on the
clerical
record?
error. It was done as a clerical error, not one of my cases. It was done as a clerical error, and they corrected a vacant land case. I can show you J51s that they adjust all the time. But when you challenge them, they don't want, just as one is adjusted, I think it was a Panagopoulos decision, which is cited, the judge said, if you don't allow an Article 78 proceeding to come in for a clerical error correction, that they have a whole website, they have a whole system in place where these issues are challenged, then you're gutting the CPLR.
But you did challenge them, and they did not correct it.
Of course, and now where do I go? Article 78, that's the only thing left. 7803.
And it's arbitrary and capricious because it's being applied unequally to the various properties.
Yes, and in the other case, it's illegal. 1802 is clear. There's 3 Supreme Court, Second Department cases, mixed-use zoning, residential, commercial. They're doing it wrong on vacant land. Someone in the Department of Finance came up with the idea one day, a few years back, that we're going to now treat vacant land with commercial overlays as commercial properties, without any basis whatsoever.
Thank you. You have time on rebuttal.
Thank you very much.
Good afternoon, Your Honors. May it please the Court, John DeBaptist representing respondents, Commissioner of Finance in the City of New York. Your Honors, we are here today to ask the Court to affirm the lower court's decision which dismissed Appellant's Article 78. This case is about...
So if the initial classification is incorrect and you're basing the assessment upon that incorrect classification, why then can the initial classification not be challenged?
Your Honor, in this case, Bajaktari, the issue is one of valuation. It's an issue of the physical increase in the property that appellants are alleging that the assessor, Finance's assessor, should have issued a physical increase, and they're trying to shoehorn this issue of valuation and say it's a clerical error, which 100+ years of case law has made clear. A clerical error only refers to an inadvertent error of mere form, as opposed to
But
errors.
again, if the classification is incorrect, why can that not be challenged? Or how would that be challenged?
Your Honor, Article 7 is the exclusive remedy for challenging claims such as misclassification claims. And in this case deals with the excessive assessment claim because petitioners alleging that there was no physical increase done.
Okay, so if they had challenged this as a clerical error, then we are back to the first case where you would have stated that it's not a clerical error?
Yes, Your Honor. In this case,
So I'm not understanding then how would they challenge it? You're saying they have to challenge it as a clerical error, but then when they do challenge it as a clerical error, then your response is it's not a clerical error. It doesn't fall under the category of a clerical error.
No, Your Honor. I think I must have misspoken.
Well, you said yes.
It cannot be brought under the clerical error rule because the clerical error rule is very narrow. The clerical error rule merely states, and in this case...
So how do you challenge a misclassification?
Through an RPTL, Article 7, which is the exclusive remedy for challenging property tax assessment.
So are you essentially saying that your adversary has not exhausted his administrative remedies?
Yes, Your Honor, because they would have to have brought, which they did in this case, in fact. The lower court said that appellants were taking 2 bites at the apple because they did bring in this case an Article 7 proceeding with, challenging the excessive assessment, which is the lack of a physical increase. So what we're saying is that is the appropriate venue to bring these type of claims in, not in Article 78, which is just looking at Finance's determination of whether or not there was a clerical error done.
So just to stage this, you're saying issue Article 7, then if there's a challenge, Article 78, or are you saying issue DOF, Article 7, Article 78? Because I think your adversary is saying issue DOF, Article 78.
Yes, so what we're saying is that the only way, someone can bring an Article 78 is to challenge a legitimate clerical error, a mere error of form, a clerical error. But what appellants are doing is they're trying to circumvent the specific Article 7, boundaries of Article 7, which in matter of 9 Orchard is exactly the same issues and as in Bajaktari. It's an identical case.
Why is this not a clerical error?
This is not a clerical error because it's an issue of valuation of whether there was a need for a physical increase or not. The assessor made a discretionary decision of judgment, looked at the replacement windows, and, you know, based on valuation standards, said that it did not, you know, the market value of the property did not go up, so no physical increase was issued. That would be challenged in an Article 7 where the judge, the special part tax or certiorari judge, would hear the expert testimony of two witnesses, the appraisers, which would, one side would say, you know, the market value is this, and the other side would say the market value is this, and the judge would make the determination.
So the assessment, the tax assessment by the assessor had nothing to do with the classification or how the property was classified?
Not in this case. This case was specifically only dealing with a physical increase and the amount of the physical increase, which is an issue of valuation.
I'd like to ask another question, if I may. Your adversary says that the property, that an increase was recognized, a 50% increase by DOF, if I understood him correctly?
Yes, Your Honor. I think what my adversary is referring to is the increase in the assessment, which again he would be able to challenge within the Article 7, but it has nothing to do with the physical increase, which here the assessor gave a 0 physical increase. That has to do with the assessed value, which
Different?
yes, two different components. Two different components of valuation. There's the physical increase and there's also equalization, which make up.
Thank you.
Thank you, Your Honor.
Just very briefly, I think that last note really hit the nail on the head. The assessor in this case, because all this work was done, and because the property became more valuable, increased the value of the property $500,000. If some portion of that would have been allocated to a physical increase, the Department of Finance would have issued a J51 exemption, although it's not even clear that a physical is required. But how is this correctable under the clerical error rule? Listen to the section of the rule, 53-02A1, failure to process a partial exemption. And they give an example of a senior citizen exemption. 5302B2, a physical change not put on the assessment roll or put on as an equalization change, which happened here. Why would a property's value go up $500,000 1 year after they changed and did all this work, put hundreds of thousands of dollars into a building and changed all these windows?
Why wouldn't you challenge that in an Article 7? Is it because the time limit was exceeded?
Well, first,
No.
it can be.
Counsel, don't speak over me kindly.
I apologize.
Thank you so much.
I apologize.
Did you choose an Article 70, the route of an Article 78 because the ability to file an Article 7 was gone?
No, we chose it because the Department of Finance routinely corrects this exact issue as a clerical error correction, as they've done for my office numerous times. Here, for some reason, they have dug in and they don't want to correct it. Once they denied that relief, the only place left for us to go was an Article 78 proceeding. We didn't commence an Article 78. We commenced a request to correct a clerical error in description. We received a final administrative denial, and then the only place left for us is Article 78 within 4 months. That was the reason. I apologize if I spoke over you. It was never my intent.
Thank you.
All right. The court has any more questions? If not, I think. Thank you.
Thank you very much. Thank you both. Eastern Effects versus 3911 Lemon. Whenever you're ready.
Good afternoon. May it please the court. Jennifer Racine of Caswitz Benson Torres on behalf of Appellants Eastern Effects. The appellants, who are a small business in New York and were a tenant in a below-market lease in Gowanus, are here appealing the decision of the lower court dismissing particular aspects of EEI, the appellant's amended complaint. There are three aspects of the complaint that were dismissed, and we are here to appeal. One is EEI's fraud claim against the landlord that I think of as Midwood, but you can see it has many small entities that comprise it for our purposes. There were two bases for that dismissal, which we will get to. One, the merger clause, and the second, a purported duplication of the contract claim.
So let's deal with the contract claim first.
Sure. With duplication, or would you like to ask about the
In
merger
terms of the
clause?
contract claim, what's
Okay.
the basis?
So
Then we can move to duplication, right?
Sure, that's fantastic. So with respect to the contract claim, it's actually really simple. There's a very long and compelling line of cases recognized by the First Department. Some of the more recent ones include Metro Life, a First Department case, and also Apple Records. And they go all the way back to the late 1880s, and that case includes the Rich case. And this whole line of cases, which we talk about on pages 32 to 34 of our moving papers or appellate papers, what they really say is that when the contract itself is the device of the fraud or a part of the larger fraud, there isn't a duplication. And that's exactly what happened here. So for example, in Apple Records, there was, in fact, a contract, and that contract was a licensing agreement. But that licensing agreement, in negotiating that licensing agreement, what the other side did not tell its counterparty was, yes, I want a licensing agreement with you, but this is only one part of a larger scheme to steal something very valuable, in that case, the Beatles portfolio. So we all sort of understand intuitively that the Beatles portfolio is very valuable.
So counsel, to cut to the chase.
Sure.
You're saying that the fraud is that they knew that there was a bulkhead and rotting timbers?
No, exactly the opposite. The fraud was that they knew that they had an assemblage of development parcels. This was one of them. They didn't want to wait 2 years until the end of the lease. And so they entered into a separate settlement agreement to get my client to willingly leave the premises for enough time so that in purporting to do the work, they could intentionally destroy the building enough.
What damage are you going to get separate and apart? I mean, part of what you look at with duplicative is that you're seeking some different type of damages. What different type of damages would be not covered by your breach of contract claim in this case that you'd be entitled to that you're seeking in the fraud claim?
Sorry, my apologies. Part of the issue here is that, and this was part of the fraud in our telling, is that part of what Midwood tried to do here is effectively on a short-term basis say, look, if you're out for just a few months, we're going to let you out for just a few months, and then we're going to get you back in. How much is that really going to cost you in terms of business interruption? And we agreed to a number that was based on short-term disruption. The difficulty here is that Midwood is going to try and use that as effectively the equivalent of a liquidated damages amount. Look, we're not going to pay you.
Why can't you say under the contract we're entitled to our full contractual rights, the benefit of the bargain, which is a contractual remedy, and that why won't that make you whole if you get the full benefit of your contractual bargain?
Well, because of the fraudulent scheme, they may have effectively destroyed our business. And so the difficulty here, and this goes to the issue of plausibility, this goes to whether or not we should, and is very connected to this question of punitive damages, which is that if knowingly there was an intent to get us out, knowing we're a small business and we were dependent upon a very, very highly specialized space that was in fact below market per contract, and we were going to be deprived of that, and that may very well have destroyed our business. And in fact, it may very well destroy our business. We should be entitled not just to contract damages, we should be entitled to be made entirely whole for all of the harm to this small business.
So as to the punitive damages, how did you plead that there was some type of independent tort and or that there was something directed to the general public?
Okay, so the independent tort is this line of cases that I'm talking about, which is the Apple line of cases, the Metro Life line of cases where the contract itself is the device. That's the separate tort. The separate tort here is let me get you out so I can intentionally destroy the building. With respect to the public policy issue, is that the landlord-tenant relationship, both commercial and residential, is a very particular relationship. Suffolk Sports talks about this. It talks about the importance of disincentivizing commercial landlords from using extra contractual.
How did you plead this?
Oh, we pleaded this, and I will cite the cases, paragraph 4, or not the cases, the paragraphs, paragraph 47, paragraph 113, we talked about what particularly the landlord did here to induce us out and the effect of that, not just on us, but on the entire community, which is one of the reasons Gowanus is considered to be interesting and special. And this happens in upzonings all over the city, which is you upzone a place that you think will rise in value. Part of the reason it rises in value is because there are established mom and pop businesses like EEI that make the place special. And in 5 years, I won't be able to go to Gowanus. Whatever they put in there will be a store that's definitely way too cool for me. But the point is that my client paved the way for that, as did the other mom and pop stores there, as will the mom and pop stores in the Bronx when there's an inevitable upzoning there. It affects everyone, and we pled that throughout the complaint in paragraphs 8 and 9, in paragraphs 18 and
It could
19.
be speculative, I mean, but you have time on rebuttal.
Okay, yes.
May it please the court, Brett Berman from Fox Rothschild on behalf of all of the respondents except for the trust. I think you hit the nail on the head, respectfully, Your Honor, when you said, what is the difference here between the contractual and non-contractual damages? None, right? So whatever they're talking about caps on liquidated damages or whatever that argument is, this is a contractual-based claim that if they're right and we couldn't exercise a casualty provision, then they get damages. If we're wrong, then they don't. I mean, if they're wrong, then they don't. I mean,
What's your response to that the damages they would get from the fraud claims are greater than, in terms of the overall damage to their business by being induced to leave the premises during the lease term?
there is no difference in those damages. That can't be articulated. That's not a legal basis. That's just a statement, right? So there's no briefing on that. There's no articulation in the complaint about how there's a difference in the contractual versus fraud damages. That's a concocted argument, with all due respect. They're seeking $7 million on the fraud claim. They're seeking $7 million on the contractual claim. What they really care about is what you got to, Your Honor, on the punitive damage claim. They hope to then keep a pigeonhole a fraud claim when it's a clear contractual claim to try to get punitive damages. They don't have a fraud claim for all of the reasons that these are identical facts, claims, damages, relief. Then they don't get punitive damages because there's no fraud claim and there's no public harm. So no matter which way you cut this, it's the same damages no matter what, as Justice Ostrager recognized. In order to try to pigeonhole these damages in a different way, they talk about this long line of cases, White, Richmond, Apple. Look at those cases, and we differentiate in those cases why they have no applicability here. Those are collateral misstatements. Those are things that were misrepresentations when you went into the contract, things that were not talked about by the contract. That's not what you have here, right? They're saying that the contract itself and the terms itself in the contract are what were the problem. That's not what those cases are. This isn't stealing the Beatles catalog, right? This is whether or not somehow in construction there was some harm and whether a casualty event arises. Do you have damages? Do you not by contract? With respect to just going a little further, they didn't get to this on the argument, but it's hotly briefed, the merger clause, right? Two ways this fraud claim fails, which is we only went to the first, duplicative, but you have a merger clause that specifically addresses what was contained in the representations in the agreement. That's a specific merger clause. But if that were not enough for this court, they lose on a second ground, which is there's the no other representation clause. And there is abundant case law in the First Department that even if you have a general merger clause, which this is not, and then you have a no misrepresentation clause or a no representation clause, you lose, and you can't have a fraud claim. And that is very clear law that is not carved out by anything that they're talking about here. They don't even address it, quite frankly, because they only went to the general clause, which again isn't general, without talking about the other provision that's the no misrepresentation. If you go further on the fraud claim, which I don't think you need to for the reason you said that these are clearly duplicative, this wasn't even a properly pled claim. What is the fraud? How was it done? It's very general, but again, I don't think that you need to go there respectfully because Justice Ostrager very clearly recognized that these are duplicative claims no matter which way you cut it. And then just finally, even if you were going to allow, just I can't be remiss to say it, somehow this fraud claim to be revived despite the 3 reasons it fails as a matter of law, this is not public policy. This speculative nature about somehow that these mom and pop businesses are going to lead to upzoning that all of a sudden makes people rich. there's a lot of law that is not the public harm we're talking about here. There's a lot of law that a landlord-tenant relationship is not a fiduciary relationship in some way. There's a lot of law that you don't get punitive damages just by saying that they did wrong. And Justice Ostrager went further and found that there was no so criminal conduct or egregious conduct. At best, what the case law says is you can't just say you went into a contract in bad faith or you acted terribly under a
I want
contract.
to go back to the bulkhead.
Sure.
The allegations that the owner knew that there was a problem with the bulkheads and that there was defective timber under the premises, and then elected to do the remediation instead of engaging an experienced contractor, which all then led to the I'm going to call it condemnation by an engineer, who said impossible to repair this. This premises is structurally defective. What do you have to say about that?
Well,
That's what supposedly led to the termination of the lease.
yeah, I don't want to argue facts, and you're driving me down a line of facts, but the contractor they're talking about, just if that really were the path we were going to go down, is one of the largest contractors in the city of New York who did this work, right? And that was why when we argued with respect to what they actually pled on fraud, they don't talk about this, how this conspiracy was, it wasn't the landlord that did this work. These were very experienced, top-of-the-line contractors that did the work. They're not the only contractor that did, they're not the only property owner that did work themselves. I mean, but again, these are facts that I think are a little deep to go into on a motion to dismiss. The basis here is that even if you accept that as true, it's still a contract claim, right? Because it's the same damages and the same facts and the same theories that are all addressed purely in the contract, right? And the final point I would make on that, because it was somewhat ironic, and I know my time is up, is when the Kronos decision, where they say, which is really the seminal issue here, that Justice Ostrager somehow didn't understand it. He wrote the underlying lower court decision on it. I think he more than understood exactly what the Kronos decision said. Respectfully, unless you have any other questions, these claims fail on multiple grounds, and the decision of Justice Ostrager should stand. Thank you.
May it please the court, my name is Kevin Fee, and I represent the Gowanus Trust. Justice Ostrager said it's the landlord, not the trust, that is responsible for any damage suffered by the tenant as a result of the landlord's allegedly negligent work on the premises. And should this court find the landlord's termination of the lease was not valid, it will be the landlord and not the trust that will be liable for any damage incurred by the tenant caused by the wrongful termination.
Let me ask you, why isn't there an ambiguity in the settlement agreement in terms of when these monthly payments are supposed to end? Because don't they go back to, they do have the language, which could be interpreted different ways, that it doesn't end until the tenant is back in possession, which the tenant never got back in possession.
Just because two parties offer different interpretations of a provision does not create ambiguity. The court, as we've laid out the cases in our brief, the court is to look at the purpose, it is to try to harmonize the provisions together, and it is to interpret it reasonably. And here, there are, the definition of construction period has to be harmonized with three other provisions, 5, 10, and 13. So the definition of construction period is in the 9th whereas clause. And it says, the work is currently scheduled to be completed during the 4-month period commencing on September 14, 2021, and terminating on January 13, 2021.
Let's get to part of it, because we only have a little bit of time. How do you deal with the language final completion? Because clearly final completion is a term that is part of the agreement, and once, as to when these payments end, and once you have that term final completion, how can you say as a matter of law that the agreement's unambiguous and it can't be construed for final completion to mean return to possession?
Because as I was just finishing, the rest of the definition says, as the same may be extended pursuant to the terms of this agreement. Section 5 talks about extensions. Section 5 does not discuss repairs as extending. Section 10 talks about repairs and ends with, such repairs shall not extend the period. And Section 13, which says we're ratifying the contract, the lease, the underlying lease, is crucial here, because now you've got these two parties offering two separate set of facts. The landlord's saying it's untenable. The tenant is saying it is not affecting the soundstage. I can use the soundstage. It's only affecting an office. If the tenant is right, the lease requires them to pay a prorated share of the rent. Under the definition of the construction period that people are using now, then they would have no obligation to pay any rent for the soundstage that they could use. They're advocating that I can use the soundstage right away. It was only minor damage into an office to the side. And Section
I'm not
13...
sure this is addressing my question, which is that they got kicked out. They're not there. They got kicked out of the premises. So based on that, why isn't there at least an argument that final completion has not occurred?
Because you go to the Section 13, which is the lease. If they were kicked out because it was untenable...
We don't know that yet.
No, if that's what the landlord is saying, that's what their position is. The tenant is saying it was tenable. But if the tenant had gone to court and said, "Get me back into the building, I can use the soundstage," and a court had done that, under the settlement agreement, Section 13, and the lease, the tenant would have to pay rent for the usable soundstage. Now,
See, that's your interpretation, and I'm not even sure that I would agree with that interpretation. But the settlement agreement says that in order for the construction period to end, plaintiff must be restored to possession. However, what about if the construction period ends, would that survive a wrongful termination of the tenancy? I mean, could you read it that way?
no, again, as Judge Ostrager read it, he said if it was a wrongful termination, it's on the landlord for the wrongful termination. It breached its obligation under Section 10, and the landlord has to pay. The clear purpose of this contract divided responsibility between the landlord and the trust. The landlord was responsible for all damage, any and all damage that arose from the construction, including this damage, they're saying, their business interruption.
But you had a separate obligation to keep making a payment till final completion of the work. And that's what we're grappling with here, whether or not, as a matter of law, final completion did or did not happen. Based on the language of the agreement, can we determine that?
Yes, you can. The purpose of the contract, harmonizing the provisions together as we've laid out in our brief, you can do it as Judge Ostrager did that. And that is that our obligation was to deal with the noise and vibration that kept them from running a sound stage. As they said, the clattering of the sound outside. That was done in May of 2021. And the damage to them, they're alleging, is our business has been interrupted because we can't get back in the building. That's the landlord's problem, as the court below said. And if you look at each of the provisions, as I said before, I laid them all out for you, and harmonize them together and look at the purpose as Judge Ostrager.
Who are the parties to the settlement agreement?
Excuse me?
Who are the parties to the settlement agreement?
The three parties here.
And the trust agreed to pay $88,000 a month until the business, what is it, EEI?
EEI, the tenant.
EI was restored to possession.
But the obligation, the landlord's obligation to repair ends with the provision, such repairs shall not extend the construction period. So, construction period was defined in whereas clause number 9. It is invoked.
When did the construction period end?
When does the construction period ended? It's not. It ended in May of 2021 when, as we laid out before, the work was done and the EPA approved it and everybody moved on.
And you're making a.
And we paid through that period. Sorry.
Thank you. You're making a line. You're saying at the point where the construction period ended, we didn't have to pay the $88,000 anymore, and the landlord at that point, at some point thereafter, said, "Oh, and you can't return to the building because it's structurally defective." And it's on the landlord. Am I understanding you correctly?
Yes. If the business interruption claim after the construction is done is on the landlord under Section 10. And that's what Judge Ostrager ruled.
Thank you.
I wanted to start by pointing out that with respect to the question concerning the difference in damages for fraud and breach of...
Can you actually first focus on the trust claim?
Sure, of course.
Because why isn't his argument right that the clear purpose of this agreement was that they were going to pay you this amount until they finished their work on the bulkhead? And it's undisputed they finished their work on the bulkhead. Why should the tenant, whatever claims the tenant may have against the landlord, why should the tenant be able to get further sums against the trust?
So look, I do think there's a tension here between equitable and contractual claims. The way this contract is set up on the face of the contract, the way that it works is that there was a separation that was negotiated between a work period and a construction period. And a work period is defined to end when the work is complete. But the obligation of the trust actually continues under the definition of construction period until we're allowed back in the building or the conclusion of the term of the lease. That was specifically negotiated into the contract. Now, whether that was...
Does it make any sense, though, for the trust to be responsible at this point? I mean, it finished its work. Why should we allow a construction of the contract which really goes against what seems to have been the real intent of the parties, which was for them to compensate you while they were building the bulkhead?
Well, I think the idea was that they should compensate during the work period, but there was always a concern on everyone's side that small issues, or then as it turned out, a large issue became the problem, but that small issues might become a tension beyond the work period, and that they may keep us out, or that the trust was concerned, I think, that we might try and stay out to continue collecting money. As it turns out, the issue wasn't a small issue, it was a very big issue, and it was caused by the landlord. But the fact of the matter is that Eastern Effects bargained very specifically for the trust to continue to pay it this base amount of money, $88,000 a month, to the end of the lease if for whatever reason it was not allowed back in, even when the work was done. That's why there's this very specific separation between the work period and the construction period. Now, do I think the parties particularly anticipated that this is the way that we would be unable to get back in? No, but it was absolutely the bargain for right of EEI to be paid by the trust, and the trust, for whatever reasons, likely that it really wanted this project bulkhead to be done so that it could complete all of its work, it was the incentive for us to get out, which was the construction period would continue until we got back in. And I think the only thing we might all agree on is the fact that we are not back in. And the trust willingly and understandingly took that on, and it was very much a central part of the incentive for EEI to get out in the first instance. So I understand it doesn't feel particularly fair, but I strongly suspect that there are extra contracts that are not before this court between these parties that would allow them to work out these issues.
Well, thank you. Thank you all. Allied World versus Greater New York.
Good afternoon, Your Honors. If it pleases the court, Mike Chauvin for Greater New York Mutual Insurance Company. We bring this appeal because the motion judge below erred in awarding interest to the excess carrier here, Allied World, who is the plaintiff respondent. This is a case in which a settlement occurred. The settlement was for $3.15 million. It occurred 11 months after verdict. A verdict that had zero interest, and that verdict was for $3.3 million, $150,000 more. And yet, the motion court below ruled, as a matter of law, without any evidence, not a citation to the record below, not a citation to the record here, that there was interest paid by plaintiff Allied World.
Do you know why that wasn't addressed in the decision below, that issue?
I'm sorry, I couldn't hear you.
Do you know why that wasn't addressed in the decision below?
I do not. It was specifically...
It was one of the arguments you made below.
Correct. So it was never addressed. It was presumed by the motion court that there was absolutely interest in this settlement. But there was not.
There's no way for us to know that based on the record we have before.
We
That's your
100%
argument,
agree
right?
with you. There's
No,
no
I'm
way.
asking, that's your argument, right? That there's no way we could know from looking at this how much of that amount that was settled was for interest versus liabilities based on the figures.
100% agree.
And your argument is that no evidence was presented below, which would have allowed the court to make that determination.
Absolutely. And in reading the court's decision below, it was presumed that there was interest, so that it was never addressed, and there, to this day, still no citation to the record to prove any interest at this point.
So, counsel,
Yes.
the verdict was 3.3 million, the judgment was 3.4 million, but the settlement was $3,150,000.
Correct.
So, is there any indication that interest was waived?
No, there's no indication that interest was waived. There's no indication that interest was paid, though. And it's the burden of the party seeking under our policy. We have a $1 million policy. It says it throughout our Greater New York Mutual primary policy. Limit is max $1 million. We will pay under the SPP, supplementary payment provision, a certain amount more for interest, but it's the burden of the party seeking coverage under our policy to prove that.
What was the response below when you made that argument? Assuming you made that argument below, it said, hey, where's the proof as interest? Did they have any response below?
They did. They cited to a provision, and it's A439 in our record. It's the settlement agreement that was reached between Allied World and Greater New York, where they say what they're claiming. It's an argument. The settlement agreement specifically lays out what their arguments are. And it says, one, the settlement agreement cannot be used for evidence, which it was being used for below, and which it's being used for now. Two, it says that it was their position that the interest was a certain amount. That's it.
So are you asking for it to be remanded so that an evidentiary determination could be made one way or another as to whether any of it was interest?
Absolutely. That's our first position. But there are other two arguments as to why it shouldn't even be remanded. So if
Why it should or should never?
should not even be remanded at this point, given that one, they can never prove the interest was paid. Two, at this point, to get
What
interest,
happens if they got an affidavit saying these were the negotiations, this is what happened from both sides, this is what we bargained for? Wouldn't that be evidence?
if we had the opportunity to depose the plaintiff, not just an affidavit, but an opportunity to depose the plaintiff, absolutely, that could be. But the plaintiff would have had to pay taxes on it. So that's why we want that opportunity. We want the evidence to see, did the actual plaintiff, Mr. Pagan.
You're saying it's their argument that, you're not arguing it shouldn't be remanded, they're arguing it shouldn't be remanded? Even if
Our
they said-
argument is, one, that it should be remanded, and that goes to the interest. They did not sustain their burden in the first place to ever prove interest, and also that they never can because it is, again,
Okay, so now there's confusion.
Right,
You
they
said,
never can, it's confusing.
you said, the question was, should it be, are you asking that we remanded for a hearing to determine whether or not the interest was paid?